equipments that we use. But are you guys all ready to go? We are here.
Yeah, I think we are. I think we are. Let me just get my notes up here 1 second.
Yeah, we're going to go on the record over here.
Okay, great. We're on the record here.
The petition. Oh, we're here in the matter of Brandon Lee Hicks and Ashley Ann Bennett.
As far as individuals that are related to the case that are on the call, I see that Ms. Bennett is here. Ms. Bennett, can you state your name and say good morning so we know you're here?
Sure.
Ms. Bennett.
Brandon Hicks is here.
Thank you, Mr. Hicks. Appreciate that. So I do see Ms. Bennett in
Ashley Bennett is here.
There she is. Great. Thank you. Judge Callahan, thanks for your patience.
Okay, so here, of course, just to complicate things a little bit, we have Mr. Hicks as the petitioner. I believe you may have Ms. Bennett as the petitioner. So when I talk, it'll be Mr. Hicks. I'll try to stay with names. Mr. Hicks filed a petition for custody and parenting time and child support with this court October 19th of 2023. Ms. Bennett responded to that petition and filed her response November 27th of 2023. Ms. Bennett then also filed a document to choose a mediator, and that was January 8th. Ms. Bennett, I'm sorry, this is Judge Callahan. Are you trying to speak or are we having trouble with our polycam?
Judge Callahan, there's probably some individuals that are on the call that are not muted. So if you're on the Zoom call, if you could just please make sure your phone is muted. That'll help reduce background noise. Sorry about that.
Thank you, Judge Evans. Yeah, not having faces or anything to look at, I'm surprised. I'm noticing how much I missed that. So Ms. Bennett did choose a mediator, or at least returned the form to choose a mediator January 8th of 2024, and then filed a completed certification of completion on 1/24 of 2024. What I can see so far, Judge Evans, is that neither perhaps of these parties have established 180 days in a row, continuous, in either of our states. They have, to their credit, and both of you parents, I'm gonna applaud you and interrupt this proceeding to applaud both of you for having worked out a parenting plan, and apparently you've been sticking with that parenting plan. I don't think there's anything that is more vital for a child than to have both parents involved in their life. So from me personally, thank you very much. So we don't have that 6 months. I can't really even make, Judge Evans, I can't make any kind of significant connection here because of the fact that they're going back and forth, and perhaps that's something I need to hear from the clients. They didn't indicate that. Mother indicates she's been the primary caretaker, but I didn't see doctors, dentists, and that type of thing, and part of it may be the age of the child. So at this point, I think that, I guess, Judge Evans, let me just ask you, you want to go ahead and give your narration and we'll see where we fall at the end of it?
You know, so just so everybody knows, Judge Callahan is a judge in Columbia County, Oregon, and under what's called the Uniform Child Custody, I forgot what the acronym means, UCCJEA, Universal Child Custody Judicial Enforcement Act. We had a previous conversation where we bandied our ideas back and forth, and we each had our notes there, and we were comparing our files. And at least my recollection is that we agreed that Oregon would have the jurisdiction, and based on that prior banting about and review of the file, that's I'll stand on that.
And I believe that is correct. Just based on the fact that we did get this started here in October of 2023, and that Ms. Bennett, you may not know all of these terms, but I think you would have waived jurisdiction in another state once you responded to the matter over here. I'm sure, I can imagine you probably didn't know, and we're just making sure that everything was covered. So if it sounds like, Judge Evans, that you are willing, that Washington is willing to decline jurisdiction at this point?
Accurate.
Okay, then we will accept jurisdiction. And I'll tell you, I don't know next where we are.
Excuse me.
Yes, Ms. Bennett, go right ahead.
I just have a couple questions. So I was told that legally I had to respond in Oregon, or that his paperwork would just go through and I wouldn't have any say. But the child actually does go to school here. He goes to the doctor here. He goes to the dentist here. He gets food stamps here. His daycare is here. Everything is in Washington.
Well, how much
But he
daycare
only started
when we're
visiting.
talking-
Sorry.
Okay, how much daycare is there?
He goes to daycare 2 to 3 days a week on the days that Brandon and I are both at work.
Okay.
But that only started in September. So he only started going to Brandon's house towards the end of September. All the other times that he had been at Brandon's house, I had been with the child.
Okay. I still do not believe that we have 6 months, 180 days of continuous residency in any one state. We have the document was filed here first. You were told correctly in that, yes, you do have to file here, but you then later went over and filed in Washington, is my understanding. Is that correct, Ms. Bennett?
Yes, because that's what I was told to do. And the child actually has lived with me up until September. So that would be 9 months that he had lived here with me in Washington.
Okay, Mr. Hicks, may I ask you for your input on that information?
Yes. Ashley was, when me and Ashley first had Bowen, she was at my residence, actually my parents, every weekend, and I'd go there on my work days. Then she would come back to my residence for the whole weekend, Friday to Sunday, if not longer sometimes.
Judge Evans, I'm still inclined to leave the matter here. I don't believe that this creates what I would think Ms. Bennett could argue later, inconvenient forum. We are literally across the bridge from each other. This is not like a Vancouver, for example, all the way up to here. It takes a little more time to get here, but with the availability of Zoom and WebEx, again, this court doesn't find that to be a hardship on anyone, including any information that Ms. Bennett may have. So for the parties, I am still going to stand by my ruling, and the state of Oregon is going to accept this case. I'm sorry, Ms. Bennett, I know that doesn't go with what you want, but we'll work it all out. Thank you all for your time. We'll get some document over to you, Judge Evans. Ma'am, I'm done now, ma'am. I'm sorry, Ms. Bennett, I've ruled.
Excuse
we're done
me.
now.
Excuse me, ma'am.
Yes.
Judge, do we still have mediation tomorrow?
Yes.
Okay. I just want to make sure I get that cleared.
Yes. Both of you go to mediation, okay?
Thank you, ma'am.
Okay, wait a minute, guys. We have a settlement conference tomorrow at 10 a.m. in this courtroom with me. I think we should cancel
courtroom
that, though.
301.
Wait, this is 311. But hang on a minute. I don't know that we should do the settlement conference prior to mediation. We're going to change that settlement conference, guys. You need to go to mediation first. Mediation is in Oregon is set up to help you with your parenting plan, which you guys have already got a good outline of one. You're walking in way better prepared than most. So go ahead and go to your mediation, and we will reschedule that settlement for a couple months out, 2 months out, I think.
And mediation is tomorrow.
Notices. Yes, and I want you to go to mediation. Ms. Bennett, you understand? I want you to go to mediation. Okay? Ms. Bennett, you still there? Judge Evans, did we lose Ms. Bennett?
She's still on the line.
Okay, so hopefully she can hear me. So you have mediation tomorrow. We're going to set over the settlement conference, and we'll send you out a notice for that.
Judge Callahan, it looks like she was in the call. She dropped off just for a moment, and then she's back in. So Ms. Bennett is back in.
Okay, Ms. Bennett, you're going to go to mediation tomorrow. Okay, you're going to go to mediation tomorrow, okay?
I thought we had a court case tomorrow.
we're going to reschedule that court date because you have to go to mediation first. So we're going to get another date about 2 months out.
Okay, so we need to do mediation tomorrow. They'll call us, or how does that work?
Should be set up. Mr. Hicks, can you tell me about? Okay. Okay, Mr. Hicks, tell me what you know about mediation at this point.
It's at 10 a.m. in room 311. That's all I know.
Okay, you are not, okay, my apologies. You are not talking about mediation at that point. You're talking about settlement. But
Okay,
I need you to go to mediation first. So, okay, let's back up, erase the tape and start over. Miss Bennett, we do not have court tomorrow, but you need to follow through on your mediator. I believe that you have chosen a mediator. I believe that he has chosen a mediator, and that you need to participate in that process. We're still going to go ahead and set the settlement conference out for 2 months. But no, you do not have anything tomorrow. Mr. Hicks, you understand that? You don't have anything tomorrow.
Yes, ma'am.
Okay, Ms. Bennett, you understand you don't have anything tomorrow?
Yes, ma'am.
Okay, so, but please continue the participation in the mediation process.
I'll call my mediator tomorrow and set up a time.
Okay. Okay, June 12th at 9 a.m. will be the new settlement conference. You'll get a notice, so it'll be written down for you. The expectation at that point is that maybe you guys have worked out your parenting plan, and that's done. We don't have to fight over visitation or parenting time. That remained, then you've got child custody and child support to talk about. The least amount of things to argue over at settlement, the better. So that's the goal anyway. If you don't work out something, that's fine. Come into court, come in for your settlement conference. We'll go over it again. Mr. Hicks, do you have any questions for the court?
No, ma'am.
Okay. Ms. Bennett, do you have any questions for the court?
I actually do. So
okay.
if Oregon has jurisdiction, does that change any of like the things that he receives in Washington?
I am not going to answer that one. Frankly, I'm not that in touch with Washington law. That would be something that you would need to speak to the different agencies about.
Okay, that's my only question.
We're going to go on. Okay. We'll figure out the correct form to send over to you, Judge Evans. And thank you very much for your time this morning. Appreciate it.
Thanks, Judge Callahan. It doesn't matter to me.
Thank you all.
Dreamer Tatum is present.
Thank you,
Judge.
judges.
Robert Tatum is on the line. Mr. Tatum? All right, Mr. Tatum, if you are on the line, I can't hear you, so make sure that you're... Oh, are you Mr. Tatum? Great, he's here present. All right, very good. All right, and also, Mr. Tatum, if you just make sure you're just in front of the microphone also, it picks up everybody's voice for recording purposes. So welcome to both parties. We're here today on a motion for temporary parenting plan and family law order. And this is a motion brought by Mr. Tatum. And we're here for that purpose. And we didn't see any response from you, Ms. Tatum. So just want to make sure, have you submitted something to the court to review?
I did not. I came to the court clerk and she told me I didn't have to, that I could just show up to court. So let me just kind of explain the process just so everybody's kind of aware. So the court works on the printed word basis, right? So Mr. Tatum here filed some motions, and he printed everything up and he explains why he wants what he wants. He sends that to you so you know what he's saying. And then in order for him to know what you want, then you need to send something back to him and say, hey, this is what I want. I agree or I disagree. And then at that point, then I know what both parties are saying because it's written. And so if we come to court, it's kind of a sense of like surprise, right? Because you've had an opportunity to review what he wants, but he hasn't had an opportunity to review what you want. And so you know, if trying to be fair to both parties, that gives everybody a full opportunity to read what the other party wants and come to court. So while I appreciate what the clerk may have said, I'm not going to allow that. Okay. You'll need to file something in writing. I did file. He actually is filing this in response to my declaration of dissolution, or I want to divorce him, and the
petition.
parenting, and I got a restraining order against him.
Right. Right. So there's a petition for dissolution that's been filed. So that's still pending. So this is part of kind of a temporary fix until the case can be finalized. So it's what they call temporary orders. So it's kind of a stopgap measure until the case can be finalized. Either it'll be finalized through a trial where the court will make a decision, or it'll be finalized through agreement between the parties. So while you responded to that petition, it's not responding to his motion, the stopgap motion.
Okay.
So it's important, at least for me, when there's a dispute between two parties, is to hear both sides from both sides. So I've heard from Mr. Tatum. I know what you want from Ms. Tatum. I'm sure she has some ideas, but I don't know what those ideas are. So as far as continuing today, I would like to know what she has to say and how that jives or doesn't jive with what Mr. Tatum is asking for. So I'm in a position to propose to the parties that we set this over to allow Ms. Tatum to type something up, give Mr. Tatum a copy, and then file a copy with the court. So generally, we look at a 2-week set over. That allows you roughly a week to file something. Then Mr. Tatum can look at that. And then if he wants to file something in reply, he can do that. And that gives him enough time for him to file a reply to you and to get into the court file. So I'm going to ask the parties what you think about today. We're the 20th, so 2 weeks would be April 3rd. And I'll ask Mr. Tatum as the moving party what your schedule looks like on April 3rd.
What was that now?
If you'd be available to come back on April
Yep.
3rd to address the motion.
Yep.
Okay. And Ms. Tatum, how does that look for your schedule?
I can take time off.
Okay. And then make sure that you get a response to the motion or the request that Mr. Tatum has submitted, and then submit your pleadings to the court, and then make sure you serve a copy on Mr. Tatum. And so then we'll be back on April 3rd and we can address the motion for a parenting plan and family law order.
So
Questions?
since there's a restraining order, I need to have a third party serve him.
That's
Okay.
true. Yeah, that is true. That is true. Any other questions?
No.
Okay. Thanks for being here today. We'll see you on the line. Denlocker, are you on the line today?
Yes, Your Honor.
All right, thanks. Welcome, sir. And Heather Lucor, are you on the line today? All right, Ms. Lucor, if you're on the line, I'm not hearing you. Please make sure you're unmuted and state your name. All right, not hearing a response from Ms. Lucor. Ms. Looney is here representing the state. And looks like as far as this is the state's motion for a temporary child support order, it looks like there was a docket notice sent to Mr. Denlocker at 2 different addresses. Mr. Denlocker, did you receive copies of the state's proposed orders and their motion?
Yes, Your Honor, I responded.
Great. And you indicated some concern that Ms. Lucor, for lack of a better term, was trying to buy you off. I read that in your response.
Yes.
Okay. And again, let me just make sure. Heather Lucor, are you on the line today, Heather Lucor? Okay, not hearing a response. I'm just going to type her name in the participant panel. And I don't see her there, so that confirms that she's not present. Okay, so I'll hear from Ms. Looney. Ms. Looney?
Thank you, Your Honor. We are proposing that we put in place a temporary order as the child is now living with Mr. Denlocker. That way, we would have an order in place that would require Ms. Lucor to pay $388 per month in child support. We have imputed her income at the minimum wage, 32 hours per week, as a recent TANF recipient. Since we have presented our proposed orders, we did receive information that Mr. Denlocker is now on TANF with the child. So we are asking that the section be filled in, that there is no deviation. We did leave that full deviation section in case the parties had come to an agreement. But now that there is TANF again for the child, we cannot recommend a lower payment for Ms. Denlocker, or I'm sorry, Ms. Lucor. That would be section 9 on page 3 of the order. We'd just be requesting that it be marked no and that there was no deviation requested.
Okay, so no deviation. Neither parent asked for a deviation from the standard calculation. That's the right one, correct?
Yes, and on section 10, we would just ask that the amount be filled in for $388 as the amount of support.
Okay.
And one additional change we are asking for is in section 11, just below that table. We did originally have April 1st, but the child began TANF on March 1st, so we're requesting that support begin March 1st.
Okay. All right, thank you. Mr. Denlocker, any questions about the proposed child support order requiring Ms. Lucor to pay $388 per month in support starting March 1?
I don't really understand the whole circumstance. I went to DSHS office, and they recommended me to apply for TANF to get the ball rolling further in child support. That was their recommendation. I told them that I did not really care to sign up for TANF, but I did actually need some more support financially. Heather bribed me $5,000, and that if that wasn't sufficient to go against your court ruling, that to pick a number. I have back owed child support. I've had my daughter since November 10th. And I don't know how long Heather was on TANF, but she basically applied for TANF because she did not want to work. She's always worked. And she recently received some inheritance from her grandmother passing, and tried to bribe me to go against your court orders. I feel like if she's able to bribe me, that, you know, at this point, I feel like I've been supporting her drug addiction and not our child for the past time that she's been on TANF. I'm kind of at a loss at what she's been doing, and forced me to take these court actions.
Okay. All right, thank you. Let me ask you, Mr. Denlocker, the state served you with a copy of a proposed child support order and also corresponding worksheets.
Yes.
Do you have any objection to those?
Well, the first one, it says the basic child support obligation is $1,073. The most recent one shows a basic child support obligation of $939. I don't really know how to address these things. I'm not a lawyer, but I do have that pulled up. Heather, since our last court date at the end of last month,
like, or maybe just more to the point, just a question. So the
Sure.
state has made a motion for child support that Ms. Lucor pay that amount starting March 1st. Are you in disagreement with that or in agreement with that?
I'm in agreement with that. I feel like the number is a little low. I don't prefer to be on TANF at all.
Sure.
That's not something I really wanted to do. I was pretty much talked into it at the DSHS office. I was so.
So I guess that there's no objection, at least from my standpoint. There's
no
for me to grant the motion that the state has requested with the modifications that Ms. Looney had mentioned as far as March and also the marking of those two boxes as far as a deviation. So I've signed both of those. So at this point, I think that the motion is complete, and I'm granting that request. So
okay.
Appreciate
Thank you, Your Honor.
Ms. Looney, thank you very much. That'll conclude the case for today. Separate tables, whatever
Thank you,
your
Your
preference
Honor.
is. Thanks. You can sit together on that's if you feel you're probably sitting there, so however you want to roll, that's fine. All right, let me just pull up my notes here one moment. So we're here on a finalization of the dissolution. It looks like there was a joinder signed by Mr. Overby, and then you wanted to have notice about what was happening, and so you got notice, and you're here today. And there's proposed orders. It looks like you both reviewed them and both signed off on them. So let me ask Ms. Overby, do you have any questions or concerns with those proposed orders that were signed by both you and Mr. Overby?
No.
Okay. And Mr. Overby, do you have any questions or concerns about those documents?
No.
Do either of you feel like you were pressured into this, or there's coercion, or somebody's holding something over your head, and you feel like this is going to be like the opportunity to say like, hey, I don't feel comfortable with this. I feel like pressure's been brought to bear, and it's too much, and I need to tell you about it.
No.
Okay. All right. So I have those orders here, and I'll sign off on each of those. You both reviewed them, and you felt comfortable with that. And then also there was just this last filing. It looks like it came in just recently about the real property description.
Yeah, the clerk recommended to include that because judges like to see it. So
Okay.
Yeah.
Okay. So, and you got a copy of that? Have you seen that?
I haven't, but I understand what it is.
Yeah, it's just it looks like it's a printout from the Calais County Assessor's Office. It shows pictures of the property, it gives a description, assessed values for 2023, the taxes, something like that. So publicly accessible information. Right, so it's that, and then let me just double check here. I have the findings and conclusions. I have the final divorce decree. The final divorce decree, sometimes that's where the real property will be addressed, and it has the property tax number there, and it has the legal description. So I think we're good with that. And this will be just nice backup if need be. So I appreciate you submitting that. And the parenting plan, which involves your 3 children. Okay, great. And then I want to just double check one of them. Okay, all right. I feel comfortable signing off on those documents. And let me just, going through a divorce is challenging at best. And when parties can work things out and come to an agreement, I think that bodes very well for your children, in that you're able to work together in a civil manner and for their benefit. And that's generally that's the sense I get with these types of orders. So thanks for working that out and doing really maybe one of the harder acts of parenting and trying to figure that out and figuring that out. So bodes well for their future, and congratulations to you both for working together to figure that out. So I'll sign those, and then if you need copies of them, you can check with the clerk's office, usually 2 or 3 days, and you can get a copy. Any questions?
No.
Okay. All right. Thank you both for being here today, and we'll take care of those. Thanks. 5-08. Robert Latham, are you on the line, please?
Yes, Your Honor, I'm on the line.
Okay.
Hope my audio is good.
Yeah, it's good. I can hear you fine. And then Ruby Engelbrecht, are you on the line? Ruby Engelbrecht, if you're on the line, please make sure you're unmuted and state your name. I'm just making sure Ruby Engelbrecht is not in the courtroom. If you are, come on forward. Okay. All right, she's not in the courtroom. So this is a motion for a parenting plan and restraining order that looks like there was a service of these. Let me just double check, Mr. Latham. I didn't receive a response from Ms. Engelbrecht. Did you receive a response from Ms. Engelbrecht?
I did not, no.
Okay.
I've talked to her a couple times since our last court meeting last week, but it's not been aligned with this conversation, something totally different.
Okay. Any discussion about her coming to court today, or whether she's anticipating coming?
No, I called her and texted her several times, and her mind is not focused on this. It's on something else, not related, unfortunately.
Okay. Yeah, like you said, we were here last week, and there was some question about the service issue, and it looks like an amended service or affidavit of or declaration of service was filed. Summons was not there in the original. In the amended, it shows that the summons was served, and then also some additional sealed financial documents. And so it looks like all those orders were served upon her, and so it looks like notice is proper, and we don't have a response from her. So what that means is that I'm in a position to grant the request that you're asking for as far as the restraining order and also the parenting plan. I do have proposed orders that were filed, and I have those here, and I'll review them with you. So this, I'm first looking at a temporary family law order, which is just a general overview type order. And then I have a parenting plan that's been submitted and related to the 3 children. And let's see, Kanoa is now 18, correct?
Yes, he has since
He's
turned 18. I originally had this whole process started in Clark County, and over that time period, he's become an adult.
Okay. And so I'm going to make one adjustment to that as far as Kanoa, since he's 18 and the parenting plan doesn't apply to him, or is he in school?
He's in college.
He's in college. Okay. All right. So I'm just going to strike through his name on the parenting plan. Any concerns with that?
No concern, sir.
All right, I'll do that. So we have the parenting plan, and the parenting plan, just a quick review of that. And then also a restraining order, which restrains Ms. Engelbrecht. Okay, and on that one, it has just the 2 children, not your older child included. All right. So with that said, I'm in a position, and we'll go ahead and sign those proposed orders. Mr. Latham, do you have any questions?
No, Your Honor. As far as the full dissolution process, is there a hearing date for the next 90 days, or I'm unsure of this process?
Yeah, it's a good question. So if you want to finalize a divorce, then you would need to file some type of motion for finalization. Generally, proposed orders would be prepared. You check with the courthouse facilitator to make sure all the documents are in proper order, make sure all the boxes are checked correctly and all that. And so you'd have to file that motion and then note it up for a hearing and give notice and service of copies of all the documents to Ms. Engelbrecht.
Understood. And is that in lieu of the original packet for dissolution?
So the original packet for dissolution, that's where you filed your petition for dissolution, the summons, the proposed parenting plan and the like. So we have the parenting plan here. Let me just take a quick look at that. Failed to notice if it's temporary or final. So the proposed order that was submitted, Mr. Latham, on the parenting plan notes that it's a temporary order, and that was based on the motion that you filed. And so you'd need to prepare orders that are finalization. So generally there will be a findings of fact and conclusions of law about a marriage. There'll be a final dissolution decree or divorce order. Generally there'll be a final parenting plan. And if child support is being sought, then a child support worksheet and also child support order. If you're not asking for that, then obviously you wouldn't be submitting something like that. So generally noted up for a motion, submit those proposed orders to Ms. Engelbrecht for her review, and then make sure that all the orders that you've prepared, the proposed orders that you've prepared, are reviewed by what's called a courthouse facilitator. Courthouse facilitator will submit that document into the court file, so there's confidence that that's been reviewed. Then we would come here for the hearing, and if Ms. Engelbrecht was in opposition, she could let us know. If she's in agreement, she can let us know, or she could choose not to come, one of the two or one of the three. So hopefully that's helpful.
Yes, thank you, Your Honor. I'll probably take a couple more trips down to the clerk's office to get some advice, but yes, thank you.
Okay, all right, very good. So that'll conclude things for today. We'll sign up on those orders. If you need copies, then please check back in 2 to 3 days. If Kimberly
Great,
Carroll
thank you,
is
Your
on the
Honor.
line today, Kimberly Carroll.
Yes, Your Honor, I'm here.
Okay, welcome. And Eddie Serapan, are you on the line today?
Yes, Your Honor.
Did I pronounce your last name correctly?
Serafane.
Serapane?
Serafane.
Fane, thank you. Great, I appreciate that. Thank you. And then we have a guardian who's assigned to the case, Ms. Turnbull. Ms. Turnbull, are you on the line?
I am.
Okay, welcome to you.
Thank you.
All right, we're here today on the review of the guardian ad litem report, which I received yesterday, and just checking with Ms. Carroll. Did you receive that?
Yes, Your Honor, I did.
And Mr. Serafan, did you receive that? The guardian ad litem report.
No, I have not.
Okay. Ms. Turnbull?
I'm sure she sent it, but yeah, I didn't get a chance to get in the email.
He was copied on the email.
Okay. Mr. Serafan, do you want to double check your email and we can come back to the case so you can
Yes.
Yeah. Okay.
Yes.
You got it?
Yes.
Okay. So what I'd like to do is just call one case and then we'll come back to your matter. So just hold tight for a little bit. That'll give Mr. Serafan just a moment to review that. Any concerns with the approach that way, Ms. Turnbull, Ms. Carroll? Okay, let's do that. We'll call that case in just a moment. If Christopher Kulichek is on the line.
Yes. Yes, Your Honor.
Okay, well, good morning. And Rebecca Knowles, are you on the line?
Yes, Your Honor.
All right, good morning. And I see that Ms. Corey is on the line also.
Yes, Your Honor.
Great. So we're here today related to the guardian ad litem report. I've read that and reviewed that. I'll double check. Did you receive a copy of that?
Yes, Your Honor.
Okay, very good. And Ms. Knowles, did you receive a copy of the guardian ad litem report?
Yes, sir.
Okay. I'll hear from Ms. Corey if you have any highlights that you'd like to address about your report, and then I'll hear from the parties.
I don't believe I have anything additional to my report at this time.
Okay.
Isa seems to be quite comfortable with her dad right now. I am asking that the court require maybe some family counseling for them as they settle into this new routine.
So when you say family counseling, is that different than the recommendation for the father to get counseling, the reconciliation counseling, or is that the reconciliation counseling?
So I would see this going as dad and Isa participating in family counseling to build their relationship, and later on mom participating with Isa doing the reconciliation counseling.
Okay.
Does that make sense?
I think so. I think what you're saying is that for father, your recommendation is for father to have counseling in support of the child. And then as the child is being guided through that reconciliation process to bring mother in and then have the therapist. Okay. Why don't you explain it a little better for me?
So I see those as two different things. So Aza is integrating into her father's family right now. And it's been a little bumpy for her and for dad, because dad has not been a full-time parent for some time. So I think it would benefit both of them to get some family counseling around those issues. And then when mom is ready to have visitation reintegrated, then I believe because of the violence in the past and the history between mom and daughter, that reconciliation counseling is going to be really a must for those two. So two separate things.
Much more clear. Thank you for the explanation. Okay, I'll hear from Mr. Kulicek as the petitioner. Anything you'd like me to know about your thoughts related to the guardian ad litem recommendations in the parenting zone?
No, Your Honor.
Okay, all right, thank you. Ms. Knowles, anything you'd like me to be aware of or know or related to?
Yes, Your Honor. So everything that Twyla put in the report that Chris is doing such a good job, that is stuff that I already had Aza in, the counseling, the everything. Aza never missed a day of school when she was with me. She's gotten suspended, expelled for drug use, for fighting. I mean, this is stuff that I was concerned about from the beginning, and I brought it up to everybody's attention. And I mean, she got expelled for doing drugs, Your Honor, at school. As well as they're saying, you know, Twyla's saying the physical assault. My daughter was arrested and charged on December 22nd for shoving me down the stairs and assaulting me. But I mean, it is what it is.
Okay, anything else?
No, sir, I still have not got, I've been calling the places for the supervised visits. I'm getting no reach back. I've asked for information. I haven't received it yet, so.
Okay, thank you. All right, so I appreciate the input from all the parties. I appreciate Ms. Corey's input in her written report. So this case is challenging in that there's been physical violence and there's been runaways and the like, and where the child is struggling and is now living at dad's house primarily, and he has some new challenges as he's learning how to parent a child after a long absence. And so, you know, taking that into consideration and the review of the file, we've addressed this case a number of times. I will nominate the father as the primary custodian of the child. The mother has indicated, you know, she mentioned that she's been having some difficulty getting in contact with the supervisor. That professional supervisor is required, and that can be up to 2 hours per week. Video visits are allowed at reasonable times and reasonable duration, and mom will be in charge of initiating that video call. Ms. Knowles will need to get a domestic violence evaluation and a substance use disorder evaluation and a mental health evaluation, and then submit those evaluations under seal to the court and provide copies to the parties. And if there's any recommended treatment, then follow through, engage in that treatment and follow through and complete it. So both parties are required, when they're communicating, to use the Our Family Wizard app. It's a subscription-based app that.
Excuse me, Your Honor.
Yes.
I got a new phone because I just got a recently new job for working for the Washington Wildlife, and it is not compatible with my phone. I cannot download it. Can we do it by email or maybe another way besides the only Wizard app?
Yeah, I would agree with that if I could, because I'm struggling trying to get that to work on my government phone. It just keeps messing it up.
Yeah, it's an issue.
Okay. Do you have ideas of how to communicate? Ms. Corey, do you have an idea? And then I'll hear from the parties.
There are dozens of other co-parenting apps, any of which would be acceptable. If you, one of you guys just want to Google co-parenting app and come up with one, as long as the other person agrees, I'm sure that would be fine.
I'm okay with us communicating over the phone.
Could you repeat that again, Ms. Knowles?
I said I'm okay with us communicating over the phone, because when I FaceTime Aza, Chris is there. There's no issue.
Okay.
I agree with that.
So, Mr. Kulichek, when you say you agree with that, tell me what you're agreeing to.
I'm agreeing with phone calls or text messages as long as, we're both agreeing, we'll, keep it cordial. I'm okay with that.
Did you have a conditional statement there, as long as if there's cordiality? Did I hear that?
Yes.
Okay. So that's been something that's been an issue in the past, and where the co-parenting apps provide a recorded third-party recording and holding on to records, and that usually helps people, not always, helps people stay on their best behavior. And if it's simply text, I think sometimes there's a tendency to have things go
Yes, sir,
south,
but
and
neither
have
one of
things
us
go
can
south fairly quickly.
access it.
Ms. Knowles, did you have a comment?
Yeah, Chris nor I cannot access our family wizard. It's been about 4 months since neither one of us have been able to access it.
Right. Yeah, it seems like our family wizard may not be a good choice. What I'd encourage the parties to do, and I'm going to require that there will be a third-party parenting communication app used by the parties. And you don't have to use our family wizard, but you have to find one that'll be compatible with your particular phones. And it may not be like this multi-functionality one like our family wizard, but there needs to be some recording of the communications between the parties. I'm not going to leave that to chance, so that'll be required. Also be aware in the parenting plan that if Mr. Kudlicek requests a urinalysis or a UA of Ms. Knowles, she'll need to do that within 6 hours. And then I think this is particularly important, that the parties don't speak poorly of the other parent in earshot of the child. And then you're also to control others within your family from doing the same. And just let me just emphasize that, because when one parent speaks poorly of the other parent and the child hears that, that's a direct attack on that child, because they're half of that other parent. And so when you say parent X is this, this, and this, the child internalizes that, and they may not do it consciously, but internally and subconsciously, it's a direct hit to their stability and their emotional well-being. So both parties are prohibited from disparaging or speaking poorly of the other. It's the golden rule, right? If you don't have anything good to say, then don't say anything at all. So that'll be part of the order. The child will need to be in counseling and stay in counseling according to the recommendations of the counselor. I'll adopt that kind of amended or maybe clarified for me requirement as far as the father being in counseling, and then also integrating that with the child. So working with the child's counselor and then working with the father and having kind of that joint counseling so that he can be supportive of the child's needs and interests. Also, then once Ms. Knowles is in a position, when the child is in a position for that reconciliation, then there'll be a reconciliation counselor that will help mother and child to reconcile to the degree that they can. And then I think it is wise for the father, Mr. Kudlicek, to complete a parenting class, an age-appropriate or developmental level where your child's at, and take that class. I think that would aid, because we could all use a little bit of help in parenting a little bit better. So I will draft that order up and circulate it amongst the parties, and I should have that by the end of this week, if not sooner. So let me ask if any party has any questions. Ms. Corey, we'll start with you.
No questions, Your Honor.
Okay, and Mr. Knowles, do you have any questions?
That's Mr. Kudlicek. I'm Miss Knowles.
I know. Sorry, I messed that up. Mr. Kudlicek, do you have any questions?
No, Your Honor.
And Ms. Knowles, do you have any questions?
Yeah, I just want to know, are there any other outlets that I can call for my supervised visits? Because it's going on almost 4 months. I've called every single place, not getting a call back. I went in person.
Okay. I would encourage you to check with Ms. Corey. She may have some insight into that. My experience has been that they tend to call back, and if not, then there may be reasons for that. But check with Ms. Corey. She may have some suggestions for you.
As far as I know, Reconnecting Families and Parents Place are the only two in Cowlitz County that do supervised visits. Okay. There are some also in the Vancouver area, if that's if you're willing to go that far.
Okay.
So I have a question, Your Honor.
Go ahead.
If I have someone that's state approved to already do my visits when it comes in regards to my son, could that person also as well supervise my visits for my daughter?
If it's a professional supervisor, that's all I'm requiring.
Yes, sir.
Okay.
Okay, so for professional, does it have, because, so she's approved for this, did all the stuff she's, I guess she's just not a professional? I don't know what's considered professional or not.
Charge you money.
What'd you say?
They charge money for they charge a fee for their service. They're licensed. They have, generally they have insurance and the like. So it has to be a professional supervisor. And Ms. Corey mentioned that there's 2 locally. So I'd encourage you to reach out to them again. All right, that'll
Yep,
complete
okay,
the case.
thank you.
I'll get that parenting plan out to the parties. Thanks.
Thank you, Your Honor.
Hampton, are you on the line today?
Thank you, Your
Yes, Your Honor, I'm here.
Okay, welcome to you, Mr. Hampton. And I'm just going to verbalize this as a reminder to myself that we're coming back to the Carol and Seraphan matter in just a moment. So both Mr. Hampton and Ms. Weed are present. This is Mr. Hampton's motion related to contempt, and it looks like their service was properly effectuated. And Ms. Weed, did you receive a copy of the motion for contempt?
Yes, it was served on Wednesday. I
Okay.
did try to get the response to him, but I have gotten it to the court.
Okay.
I filed it on Monday. I took it out to his mom's house, the address that he listed. There was no answer.
Okay. All right. So I'll tell you where I'm at. I've reviewed Mr. Hampton's motion related to the seeing the child and the like, and then I was looking for double check one item. Mr. Hampton, did you receive a copy of Ms. Weed's response? It looks like it's about a 20-page document, roughly, with attachments. Yeah.
I did not.
Okay. So generally what we like to see happen is that have both parties know what the other party has said and written. So when everybody comes together, there's no surprises and everybody's free and fully advised to argue their case. So I'm wondering, let me double check on another item here. So what I see is that your declaration made it into the file, the one that you said you filed on Monday. Mr. Hampton hasn't seen that. Is that something that you could mail to him and then file a declaration of service?
I can, yes. Yeah,
Okay.
I could even do it by email if
Okay.
that would be faster.
Mr. Hampton, sometimes generally service is required. Either it can be done in person in certain situations, or it can be done via mail in other situations. And if the parties agree, it can be done via email. As a general rule, that makes life a little bit easier for everybody involved. So I just want to know if you have any preference as far as how to receive documents and service from Ms. Weed.
Email's just fine.
Okay. And do you have his email?
I do not have his email.
Mr. Hampton, we're in a public forum and some people are a little bit squeamish about sharing their email. Others are not. Where do you stand?
I mean, it doesn't really bother me. I also, if Lisa has, if I'm still, I don't get any messages back when I text her. So if she's still receiving my messages, I can go ahead and just text it to her.
I am receiving his messages.
You are, you say?
Mm-hmm.
Okay. So Ms. Weed indicates she is receiving your messages. So if you want to text that to her right now, do you have your phone?
I do not.
You don't have it with you. Okay.
Sorry.
No, it's okay. So Mr. Hampton, if you wanted to send that, your email address to her, send it via text and also send it via email, just to make sure that she has it. And then once she receives that information, then she can send you a copy of her declaration, so you can review it, and then you can respond if you'd like. And then Ms. Weed, you'll just need to fill out a declaration of service that you've served it via email, and then we can come back and address the issues that are brought forward. I don't want to wait too long because the allegations are that it's been a long time of withholding or not seeing the child. So I'll ask the parties if coming back next week on the 27th, how does that look for you, Ms. Weed?
I'm open. Mr.
Hampton?
Yes, Your Honor, that works. May I also add that you mentioned just a second ago that you wanted me to send it as a text message and as an email.
Yep.
I don't have Mrs. Weed's email address, so I can only send it text message wise.
Okay.
I can state my email if you'd like.
Okay. Mr. Hampton, do you have a writing instrument available to you?
Yes, Your Honor.
Okay. All right, so if you do us that favor, please, Mr. Hampton, just send your email address via text and email. That'd be great.
You bet.
All right, so we'll be back here on the 27th of March, and then Ms. Weed will supply a copy of her declaration to Mr. Hampton, and then we'll be here on the 27th to address the issues raised.
What time, Your Honor?
9 a.m.
Okay, thank you.
All right, Mr. Hampton, any final questions?
No, sir.
All right, Ms. Weed, any final questions?
No.
Okay, we'll see everybody next week. And just confirm that everybody's there. I see that Mr. Eddie Serafan's present, Ms. Kimberly Carroll is present, and Ms. Turnbull. Is Ms. Turnbull here? Okay, so Mr. Serafan, were you able to open and review that guardian ad litem report that was filed by Ms. Turnbull?
Yes, Your Honor.
Okay. And Mr. Serafan, do you feel comfortable moving forward today talking about that, having read Ms. Turnbull's recommendations, what she thinks is appropriate?
Yes, Your Honor.
Okay, very good. All right, so we'll hear from Ms. Turnbull first, and if there's any highlights you'd like to emphasize with your report, I've reviewed it and I took note of your recommendations and some issues that were raised. Then after hearing from Ms. Turnbull, then we'd hear from Ms. Carroll, then Mr. Serafan. Ms. Turnbull?
Okay, I think it's, my report, I think, speaks to the issues. There's quite a bit of documented history in both the police reports and in Odyssey that speak to both domestic violence and substance abuse.
Can I ask you one question? I noted in your report, and then I saw the watch reports you filed as far as criminal history. As far as Ms. Carroll's current husband, I think Mr. Corey, you said something.
Carroll, Mr. Carroll.
Carroll, sorry. Is it Corey Carroll?
Corey Carroll.
There was something you mentioned in your report that I didn't see. It was supported by a watch report. It's something that you said as late as 2022, but I didn't see anything in the watch report, and I may have overlooked it.
There's a protection order.
Okay.
In place from a previous relationship.
Okay, and that was entered recently in 2022.
Correct.
But it's not an allegation of a violation of that protection order.
That's correct.
Okay. All right. Thanks for the clarification. I appreciate that. All right. Anything else, Ms. Turnbull?
Not at this time.
Okay. Thanks. All right, Ms. Carroll, you're the petitioner, so I'll hear from you if you have any thoughts related to Ms. Turnbull's recommendations and report.
I reviewed it and it seems pretty thorough. She did, there was a question that I had kind of thought about in reference to my oldest child and her environment when she did stay with her dad. That wasn't really noted, and it was the food issue, having to supply her with food and having her come home many nights for dinner and things like that because there just wasn't any food in the home. And
how long did your eldest daughter stay with dad?
It was 3.5 months.
Okay. All right. And when did she come back home to your home?
2 weeks ago.
2 weeks ago. Okay. Sorry, I interrupted. Go ahead, please.
It's okay. And then at one point, his oldest daughter was ordering food to be delivered as well for her. Just because she's very tiny, very active in school and does a lot of sports. And so it's really easy for her to lose body weight quickly. And she's very shy and being worked up for being on the spectrum for autism. So her communication isn't very good. So we had to end up figuring out that she was kind of malnourished and had to step up, and I bought her groceries, and then her older sister sent her food as well. And so I didn't note that if that was in part of the home inspection or if his fridge is not full or not, but that was one of the issues too that I was concerned about.
Okay. Thanks. Any further input?
Not at this time, no.
Okay. Mr. Serafan, what are your thoughts?
So on the food situation, Your Honor, so the food, I have no problems feeding them. You know, there's time that I'll Venmo my kids when they're off school, they need money for food. And as like most of the food that's in here, I ask her, go ahead, you can eat it. But my Tia's son, she has food for her son. And sometimes, honestly, I said, whatever you want to eat, ask first, because a lot of this is not mine. So she'll, you know, like wrestling, when she used to take that, takes wrestling. She'll take food and she'll take it, with her, and like, where the bread go? Where's the loaf of bread? Where's the peanut butter? Oh, I took it with me. I mean, on the food, there's no, she never had a problem eating here. I'm always feeding her. And I don't know why she brought this up, because honestly, even telling me herself, she's too busy to eat sometimes. And on the food situation, the stuff that my daughter brought to her, those are all the extra she said she ordered, and she gave it to her because she didn't have time to cook, honestly. So all that food that she got, that was like, because she ordered extra. That's what she said.
We still have it.
And we still have it.
Right. And then other thoughts you have related to the recommendations of the guardian ad litem?
Not really, no, unless it's brought up.
Okay. So the guardian ad litem is making a recommendation that Ms. Carroll be nominated as the primary custodial parent, that you would have supervised visits with the children 2 times a week for 2 hours each, that Ms. Carroll would have sole decision-making related to non-emergency care and also school and education, and that she's recommending that you get a substance use evaluation and a domestic violence evaluation, follow up with any recommended treatment on both. That both parties both Ms. Carroll and yourself take the impact of domestic violence on children class, and that both parties have refrain from speaking poorly of the other. No disparaging remarks. So that's the recommendations. Do you have any comments about any of those?
No.
Okay. Well,
Could I just mention one other thing, Your Honor?
Yeah, sure.
For as far as communication, could I ask that it just go through me if he wants our youngest daughter to call him? Because what happens is he won't call the home phone that's for all the kids to talk at any time. He'll ask my younger son or my oldest to ask my daughter to call him to communicate with him. And I'd rather that just either he take the initiative to call the home phone and talk to her, or just ask me to have her call him. It just puts them in a weird spot.
How old is that daughter?
She's 9.
9 years old. So your request would be that if dad wants to chat with 9-year-old, that say he texts you or call you and say, I want to talk to my daughter, my 9-year-old, and then you get her on the phone.
Yeah. And he has the home number and can call at any time.
Okay. Mr. Serafan, any thoughts about that?
No, I mean, I guess we could do that now. Before I didn't have that problem, but yeah.
Okay.
My younger two have just they're just constantly, hey, dad wants you to call him. Hey, dad wants you to call him. And I mean, there's a phone, and I think that should be, his responsibility to reach out to her, not have his other 2 kids ask her to call him. And so it's just, if I could request that, that's what I'm requesting today too.
Okay. Any further questions on that, Mr. Serafan, or input?
Oh, Your Honor. It's just I'm busy with work sometimes. And as for honestly saying that I don't have time for her, I try to do as much as I can. When she left her mom's house, I was waking up 6, 7 in the morning to take her to fire science and to work to Ridgeville. I was tired and I was going to work, and then she decided not to go anymore. I accepted that, and she just went to school in the fire science. And then I'm still doing, before when she was here, I was still doing that. And I don't know. I did what I can for her. It's just sucks. Now she's just, saying all this negative stuff about me. I feel like her mom sent her over here just to, see what's going around the house. And then when it got close, she's dipped back out to her mom.
Okay. All right. I appreciate the input from all the parties. I'll just double check with Ms. Turnbull if you have any final comments or observations.
No, I think that Ms. Carroll's request is appropriate in terms of, and I think, yeah, that's about all.
Okay. I'm just going to make a quick notation for myself. I appreciate everybody participating and hearing your input. One thing that just strikes me is that children obviously are best served, and their interests are well served when they have good communication and good relationship with both parents. And hopefully this parenting plan can promote that, and both parties and the children can have good relationships with each other. So the recommendations, there's a basis for those recommendations. So I'm going to follow that and order a parenting plan that I'll give orally now, and then prior to Friday of this week, I'll have printed it out and submitted it to the court, and I'll send copies to the parties at the addresses listed in the court file. There's some concerns related to marijuana use and domestic violence and the like, and disparaging of the other party. So I'll note and rule that Ms. Carroll will be the primary custodial parent. Sounds like that's been the case for a while. Dad will. There's no objection from him of having supervised visit 2 hours a week, 2 times a week, and that sole decision making related to non-emergent healthcare and also education will vest in Ms. Carroll. And then Mr. Serafan will need to get a substance use evaluation and also a domestic violence evaluation and follow up with any recommended treatment. And then encourage both parties to take that impact on domestic violence children class. I'll require that. I ask, but it's required. And so once you've completed that, please send a proof of that to the court and have it filed and send a copy to the other parties and the GAL. I think this is important. You may have heard me mention this earlier, is that when children hear good, positive things about the other parent, that's in effect, the child is receiving good and positive things about themselves. That's how they receive it. When a child receives negative and harsh things said about the other parent, said by another parent, that has a harsh negative impact on them because half of them is the other parent. And so when you speak poorly of another parent, it's speaking poorly of the child and it attacks them and damages them. So please don't do that and do your best to refrain from doing that. So that's a court order not to make disparaging remarks where the child can hear that.
I'm not concerned about.
Obviously, there's some discipline and parenting differences between the parties, pretty stark, it seems. And so that's part of the reason why I'm granting that, the recommendations. So I will get that drafted and send that out to the parties. Any questions from any party, Ms. Carroll or Mr. Serafan?
No, Your Honor.
Right. And Ms. Turnbull, any questions on your end?
No questions.
Okay. All right. Well, I appreciate the party's input. I'll get that order out to the parties and you can move forward and carrying and rearing your children. Jonathan Butcher, are you here?
Thank you, Your Honor.
Yes, Your Honor, I'm here.
Okay. Welcome to you. And Dee Stillwell, are you here?
I'm here, Your Honor.
Okay. Welcome, Ms. Stillwell. And Ms. Turnbull is present. This is related to a couple of different things. There's the motion a new motion related to waive the guardian ad litem payment and have it be a county pay that's brought by Ms. Stillwell. There's also Ms. Stillwell's motion for contempt regarding the tax exemption, which we talked a little bit last time, and then the final GAL report. And so I'll first hear from Ms. Turnbull.
So I have not received any additional payment. I was waiting until today's decision, and I'm ready to write that report and get it filed.
Okay, so maybe if the parties don't mind, maybe we could just address Ms. Stillwell's motion to waive or alternatively have the county pay for her portion of the GAL fee. Ms. Stillwell, do you want to just address that? I read your motion related to your net income, I think is about $2,700 a month. Is that accurate?
Yeah, it's about $2,600 a month, and now I'm got a single income. I'm struggling to pay my bills, and now that I've got child support taken out, it's almost one of my paychecks alone. I am financially not able to pay the guardian ad litem fees.
Okay, thank you. Mr. Butcher, do you have any comment related to the motion?
I understand the situation now. I do know that the guardian ad litem fee was long before child support was ordered. But it is one of those things where I just want to get the ball rolling and get things moving.
Okay, thanks. I think what persuades me to grant the motion and have the county do a county pay is the new or newly imposed child support obligation, which really is dramatic as far as in comparison to the net income. So I'll grant that motion that was brought by Ms. Stillwell. So
Thank you, Your Honor.
What I need to do is, I don't know, Ms. Stillwell, did you submit a proposed order related to that?
That I believe I did.
Okay, let's double check. All right, so I don't see it. So I think probably what I'll do is that form is readily available for me. And I'm just going to write myself a note here to draft that order that it's a county will pay Ms. Stillwell's portion of the guardian ad litem fee. And so with that, Ms. Ms. Turnbull, that would allow you then to, with payment, then move forward and finalizing your report and getting everything done.
Yes.
Okay. All right. So let me just put that notation there and give myself a little orange highlight to tell me that's something I need to do. So I've got that. All right. So then that brings us to the next issue, the motion related to the tax exemption. And also, so I think Ms. Turnbull, at this point, I think you're probably free to go unless you want to stay on the line.
Okay. Fantastic. Thank you, Your Honor.
Okay, thanks. Okay, so Ms. Stillwell, this is your motion related to the tax issue and the tax exemption. And I just want to make sure you receive copies of the document that Mr. Butcher submitted to the court after our last hearing.
I never received anything.
Okay, let's touch base with Mr. Butcher. Mr. Butcher, as far as that document that you supplied to the court, did you give a copy to Ms. Stillwell?
Those are the same papers that I had turned in before. I went in to talk to the clerks, and they had just misfiled it with the declaration. It was supposed to be done separate. I didn't actually have to turn in any additional papers. They already had them.
Oh, okay.
Okay, it was just the tax information?
Yeah.
Yeah, it was related
Okay,
to the tax.
I did have copies of those from it in the past.
Okay, let me just make sure I'm here with you all one moment. So this is just to make sure we're on the same page here. So on the 8th of March, it looks like there was a sealed financial source document filed by Mr. Butcher, which included a pay stub, and also it looks like just kind of summary pages of filing of taxes where it lists the dependents that were claimed. And so I have that. Is that the document that you're talking about, Mr. Butcher? That was
yes.
Okay. And Ms. Stillwell, is that the document that you've seen that?
The tax information, correct.
Yeah, and the tax information, what I'm looking at, it says tax year, top left corner, and then it says client and has a name, John Butcher, and then a social security number, and it shows a process date, 2022. And then down below, about top third, it says dependent names, and it lists, at least on that 2021 tax year, 4 individuals. In 2022, it lists 2 individuals, which these are your children.
Correct.
So, and then 2020, it lists 2 children. 2019, it lists 2 children. So that's the document I'm looking at. Make sure that you have that, Ms. Stillwell.
I do. I don't know where it is right now, but
Okay,
I do have.
Okay, so you've looked at it.
Yes.
Okay.
I did file a declaration on the 15th that does state I did get a hold of IRS to figure out what to do about the 2022 tax because I was supposed to be able to claim the girls. I've got to call them again to verify. They told me to file a form that is it is a theft or identity theft affidavit.
Right.
So I have filed that. I do have to get a hold of IRS again to make sure that they got that so I can file a amended tax return for year 2022. So those taxes will be fixed by the IRS.
Right. Okay. Yeah, I reviewed that declaration that you submitted. And so looking at the documents that were filed on March 8th related to the tax year 2022, that's the one that's a question here. That particular document shows that Mr. Butcher, it looks like he claimed Elijah and Braden and only them. But then apparently looks like somebody else has claimed the other 2 children. And that's why you're filing that affidavit.
With the IRS, yes.
The IRS. So what's your position, Ms. Stillwell, about your motion related to contempt? Because in the contempt motion, you say, hey, Mr. Butcher claimed all 4 kids on the 2022 taxes. And
I'm getting that taken care of, but with the IRS, but I still believe I should be reimbursed the $4,200, which I put on the declaration for the year 2021, or I should be able to claim all 4 children for 2023 taxes.
So in 2021, according to the declaration or the financial documents that Mr. Butcher, you filed, it shows in 2021 you claimed the 4 children. Is that correct?
Correct.
And the order from March 14th indicates that each parent gets to claim, mom gets to claim Alex and Lennox each year, and dad gets to claim Elijah and Braden each year. But in 2021, it shows that you claimed all 4. Help me understand what's happening there, Mr. Butcher.
That was that January of the year that I claimed them. The kids were removed from her house, and they did not go back until the next year. I had them 100%, and I did not file accordingly with a motion to change the how we could claim them, because I did not know that I had to file that separately versus the parenting plan that was put in. And so I claimed them thinking that it was all connected when it was not. But I had them 100% that year, and that's why I claimed all 4.
And that's in 2021, that calendar year, you're saying that you had all children in 2021?
Correct.
Okay. Ms. Stillwell?
That's when we were going through court. I did have the kids every Saturday, and then it did turn to Saturday, Sunday.
Okay.
Supervised
every weekend. But
Okay.
still, he went against the court order.
So you had the kids in 2021 on Saturdays and Sundays, basically?
Yes.
For supervised visits for a couple hours each day.
Is that
Towards the end of the year.
Ms. Stillwell, do you agree with that? Were there overnights involved, or just were they day visits?
I can't remember everyone, but we were trying to get it back to where it was every weekend or every Saturday. It did change to actually there was overnight visits that year as well, because this has been an ongoing case. I did get the kids overnight. It was changed to 50-50, but then it got cut back to every weekend.
Okay.
So it's been an ongoing case.
Gotcha. Okay. All right. So we're dealing with Ms. Stillwell's motion is for 2 tax years. The basis of the motion is the March 14, 2019 order, which basically says mom claims Alex and Lennox each year, and dad claims Elijah and Braden each year. We know in 2022, at least the evidence that's here before the court is that Mr. Butcher claimed the two boys on his taxes, not claiming the girls. So I don't find a violation there of the court order. So I find no contempt for 2022 tax year. 2021 tax year is a bit different in that Mr. Butcher claimed all 4 children, which is technically in violation of that March 2019 order that says he only gets to claim 2. I guess one of the mitigating factors about that situation that both parties agree is that during that year of the calendar year of 2021, that Mr. Butcher had custody of all of the children, and mom had visitations on weekends with maybe later in the year with an overnight or a few, but generally day visits Saturday and Sunday, and maybe it started out Saturday and then expanded to Sunday. So a limited period of time. So the important part, at least in my mind, to remember about child support is a means by which parents have the ability to sustain and support their children financially with the needs of life. And the purpose is generally the parent who maybe has, in general terms, has the children less time, therefore incurs less costs, less food, less gas, less electricity, and the like. So in this situation in 2021, Mr. Butcher had the children and was expending those funds to support the children. And part of the reason is that with tax exemptions, that also ties into that same rationale, is that a parent is expending dollars to sustain their children during the tax year, and therefore the IRS says, hey, look, according to the tax code, you can claim that child as a benefit. We want to promote that as a policy within the IRS policy to promote parents caring for their children. Therefore, they grant an exemption for parents for caring for their children. So while there's technically a violation of the 2021 order, I think given the circumstances and the mitigating circumstances that Mr. Butcher had custody of the children, I'm going to find a non-violation of the contempt because I think the import of all of these orders is to provide for the well-being of the children and care for them. I think that was accomplished here, and if I were to find a violation, it would go against the spirit of that order. So I'll find non-violation for 2021 and also 2022. So I think that addresses the contempt motion that was brought before the court. I'll be filing an order basically denying denying the contempt. And then that'll leave Ms. Stillwell in a position where she can follow through with the IRS and try to figure out what's going on. And with the denial, that also means that I'm not ordering Mr. Butcher to disgorge any funds or make any payment. So that'll conclude today's hearing. I'll file that document before Friday afternoon, and then the parties will, and I'll send it out to the address listed in the court file for your review. I'll ask Mr. Butcher, do you have any questions?
No questions about that. Just are we? I know that there was tax information inputted on the child support work order. Are we clear to file taxes this year, or should we still hold off, or is there any changes that need to be made beyond what was already on the child support work order?
So when the child support, to my knowledge, is still based on, unless there's been a change since March 2019. Has there been a change of the child support?
No, it's just on the child support work order. It does address IRS and tax claims.
So there was a March 6, 2024, there was an order of child support entered, correct?
Yes.
Okay, and so as far as tax, what does that say on that order?
All it says is that we follow the IRS laws and follow their policies.
Okay, yeah, the parties will follow the law and IRS rules about claiming children on tax forms. So that's an area that's not directly addressed about who gets to claim who and what years and what have you. I'm assuming when the hearing on March 6th, was that directly addressed related to that child support order?
No.
Mr. Butcher?
No, the subject of taxes were not brought up, nor did we specifically address that line.
Okay. Okay. Ms. Silva indicated that it was not also. She indicated it was not addressed. So right now, as it stands, there's an order that says basically you just need to follow the rules that IRS sets. There's a precedent where the parties have been basically splitting it down the middle for taxes. So I'm not, I'm not in the business of giving prospective rulings. The court made a ruling on March 8th and signing that child support order. That's the if you will, the law that controls the case. If there were to be a motion brought, then the court would need to rule on that and make a decision. I have a fairly clear idea in my mind, without hearing from the parties, and so that wouldn't be necessarily appropriate for me to say that or speak that. So claiming the children for tax year 2023 is up in the air, it sounds like, for the parties, correct?
As far as I know, it would be the split in the middle like we have in the past.
Right, Mr. Butcher?
I'm okay doing that. I also have concerns with like the guardian ad litem, the final report, what's it going to say, and what we're doing with parenting plans after that. I do know the IRS tax laws are different, and that's why, but they're also kind of vague.
Mm-hmm.
So
sure. So yeah, what the guardian ad litem says or chimes in as far as parenting plan, we'll have to see what happens to that. But again, tax year 2023 has happened in the past, and if the parties want to agree to what you were doing in the past, based on the 2019 order, that's obviously encouraged. If the parties cannot come to an agreement, then you'd need to file a motion to have the court rule on that. So I am always of the opinion that if parties can agree to a particular provision, it's always better. You're closer to the situation than I. So if you can agree as to that issue of the tax exemption claim, please do so. If you can't, then file a motion. So okay. I hope that answers the question. Okay.
Yeah.
Okay. All right. So at this point, we've addressed the motion for contempt, the motion for the guardian ad litem payment. I think we're addressing all the issues at this point. I'll double check with the parties to see if there's any outstanding items that were noted for today but have not been addressed. Mr. Butcher?
No, everything seems addressed. We will continue with the previous splitting them down the middle for this tax season and move forward as necessary for later.
Okay, and that's for tax year 2023.
Yep.
Okay, Ms. Stillwell, any final questions, queries?
That's everything. When would our next court date be? since we have everything going with the guardian ad litem?
Yeah, at this point, we're not setting a date. The guardian ad litem, I probably should have asked her before she signed off of what our expected timeframes were. Generally, what'll happen if a date is not set, the guardian ad litem will submit their report and then note it up for a hearing, giving all parties notice. And if you find that the guardian ad litem submits the report and there's no date, and you want to have the case heard, then either of you could note it up to be heard on the guardian ad litem report.
Okay.
There was a notice of a hearing for the 10th to address the motions that she just put in the other day. Is that still standing, or is that one going to be removed for now?
You say the motion that was filed on the 10th?
Yeah, they told me I had to put a date out 21 days from when I filed for the motion to waive the guardian ad litem fees.
Oh, yeah.
So they said I couldn't put it for today's date.
Okay. Oh, I see what you're talking about.
Since it was addressed today.
Yeah, let's strike the hearing on April 10th. We've addressed it today. Okay. Is that okay, Mr. Butcher?
That's perfect, because I wouldn't be able to make it on the 10th.
Okay. All right. So we'll strike the April 10th hearing related to the issue that we addressed today about GAL payment.
All right. Okay. Thank you.
Great.
Thank you.
And that'll conclude the hearing. Thank you. Lyon is on the line. Carl Lyon.
Yeah, I'm here, Your Honor.
Okay. Welcome, Mr. Lyon. Welcome to you, Mr. Blonsky. So we were here not too long ago, and we're here on Mr. Lyon's motion for a full restraining order. And so just kind of checking base with the parties to see what updates. I read that there were some updates that were provided, I think, by Ms. Jablonski related to communications from CPS. Maybe that, yeah, CPS and the detective out in Umatilla talking about it. So I reviewed that, and I also reviewed the watch report, which Ms. Jablonski indicated that she felt like, well, there's nothing on there related to the investigation, right? That was kind of your rationale for putting that in, or?
Mr. Lyon said that my spouse had a felon. So that was just kind of evidence stating that there was no felons at all in the home. So it's not in violation of our parenting plan.
Gotcha. Okay. Thanks. Appreciate that. All right. Mr. Lyon, this is your motion. So I'll hear from you to see if you have any updated information. It sounds like at this point, CPS, they haven't issued any determinations. Law enforcement hasn't taken any action. Is that where we're at?
I have my CPS caseworker Cassie Talbot here with me. And she has recommendations.
Okay, Mr. Lyon, can you turn on your camera for me, please?
Sure. Might have to join back with a different device or something. I'm having some technical difficulties with my camera.
Okay. Maybe you kind of just work on that as we're talking.
Okay.
So let's so as far as you mentioned the CPS worker is there, so I'm just curious if there's any updates related to their investigation, any updates related to law enforcement.
Hello, this is Cassie Talbot. I'm with ODHS Child Welfare. So I have completed the assessment. It is pending approval with my supervisor, and it is going to be founded for use to by Christopher Vaughn.
So you say it will be that?
Yeah.
How do you know that?
Because it's been approved. It was kicked back because there might be another allegation that we need to add. That information I do not have as of yet. I have not had a chance to stop with my supervisor, but she said everything else was looking good. And we do have reasonable cause to believe that abuse did occur.
And when will that founded letter be issued?
I'm hoping by the end of the week.
So there's not a firm date, but hopefully by the end of the week.
Mm-hmm.
Okay. All right. Thank you. Mr. Lyon, any updates as far as law enforcement?
I haven't heard anything back from Mr. Morris at this time.
Okay. All right, Mr. Blonsky.
Judge, I have attached a document from Mr. Morris stating that there is no criminal proceedings in Oregon. I also had Scott on. But
Can I ask you a question on that? I apologize.
Yeah.
So they said that they weren't going to do anything in Oregon because they indicated that the alleged alleged crime occurred in the state of Washington. That's why they're declining to do anything more, right?
That is correct. And I've spoken with Detective Nastansky on the Washington side, and I haven't got any new information. I have also attached documents where I provided Christopher Vaughn's information to Ms. Nastansky, and she has not reached out. I've reached out several times to Cassie Talbot, and this is the first that I've been told any new information. I emailed her on, I want to say it was March 6th. I emailed her February 13th. She responded back, which the emails are attached, not until March 6th. When I asked her for new updates, she told me she had nothing.
Okay. All right.
I still haven't heard about the forensic. I still haven't heard about the medical exam. Nothing has been communicated.
So, Ms. Talbot, do you know if there's been a forensic examination of the child or any other type of examination?
Okay.
Oh, sorry. Yes, there has. I actually have documentation here of the times that I have spoke to Tara. If you give me just a second, I'm going to go through here and see if I can find the.
So I'm not necessarily looking for your communications or contact with the child. Ms. Jablonski indicated that she was talking about a forensic examination or other type of like physical
Medical exam.
A medical exam.
They told me that they were going to take him and provide medical exams and forensic interviews. Now I was told that Detective Morris passed that on to Detective Nastansky.
And at that point, you haven't heard from Stansky.
That is correct.
Okay.
And I'm told that Scott cannot proceed with his job duties unless the kids are here underneath my presence in order to close this investigation up. Now, when I spoke with Nastansky just recently last week, she told me that she was getting ready to close out the case herself too, that she just had a few more questions to ask Casey in regards to the investigation, as well as reach out to Chris, which has not happened yet.
Okay, tell me who Chris is. Who's Chris?
And that is the spouse that is being accused of the allegation.
Okay, cool. Okay. All right. There's a lot of names going around. So
Well, yeah, there's 2 different states involved and 6 different people involved in this. So
right.
it's very
Yeah.
hearsay.
So Ms. Jablonski, so Mr. Lyon has filed this motion for a full restraining order related to the concerns of sexual abuse. Your position is, I'm assuming that you're saying you're objecting to that. Is that accurate?
That is accurate.
Okay. All right.
I haven't seen my kids in a month and a half.
Okay. And then so you live in Olympia area?
Correct.
And then Mr. Lyon lives in Pendleton?
Yes.
What's the distance?
It's a 5-hour distance.
It's 5 hours. Okay. And under the temporary order, restraining order that's in place, there's a blanket prohibition of contact between you and the kids.
Yes.
Okay. Mr. Lyon, what's your position as far as Ms. Jablonski having contact with the children?
I'm absolutely fine with her being able to talk to and FaceTime with the children. I'm even open to doing supervised visitation.
Ms. Jablonski, what is your desire, wish related to either video visits and or visitation?
I am requesting that we resume back to our parenting plan. Scott, he had to go attend another unit team meeting, but he was on this Zoom hearing. He just couldn't wait any longer. But him and I have in place a plan to put into action when the kids do come home that will keep Christopher Vaughn away from the home until we get that paperwork that says whether or not it was founded or unfounded.
Right.
For their protection, for my protection, that's what we want to do.
Okay. All right. Thank you. And let me just pull up the parenting plan that you reference.
And Judge, real quick.
Go ahead.
When I spoke with Mr. Lyon on the 12th, because I drove out to Pendleton, Oregon on the 12th, because I submitted some documents with the court. In order to get him served, I had to go down to Pendleton myself and give them to the sheriff to have them serve him.
Okay.
Now, during that phone conversation, I talked with Mr. Lyon prior to me driving down there. At that time, Mr. Lyon told me that he didn't want the restraining order, that he was pressured by counsel.
So Mr. Lyon, please don't interrupt.
Sorry.
He told me that he was highly advised because she couldn't extend the temporary action plan, that he was pressured and forced into doing it. And
okay.
I do have all that documented as well.
Okay. All right. So the current parenting plan is the one from December of 2018.
Correct.
Which gives custody to Mr. Lyon, and then Ms. Jablonski has shows The kids are in school now, right? They're older now?
Yes.
Okay.
Yes.
So it's every week, Friday at 5 to Monday at noon is the current plan.
Correct. It has been an issue. Mr. Lyon's been actually in contempt because he's moved to Walla Walla and now Pendleton, which is against our parenting plan. He has yet to file an affidavit of relocation for both locations. So it's kind of like an ongoing process.
Sure. Okay. So I won't get into the relocation issue. That's something that's not necessarily before the court, some information
Correct.
for the court to consider. So I think right now where the indication is that there's a likely indication from division, I'm not sure the correct title, CPS or Child Protective Services or Division of Child, Youth and Family and the like, with that indication that there's likely some action going to be taken. There's an incomplete law enforcement investigation that sounds like it's nearing completion. I think there's enough smoke and concern to have to proceed cautiously. I think it's important for Ms. Jablonski to have contact with the children. The allegation is it's not her. She's not the one that's being investigated. The concern is that her partner is the one that's being investigated in relation to the children. Of course, there's obviously a clear connection between Ms. Jablonski and her partner and also the children. But here there's no direct claim that Ms. Jablonski has caused direct harm to the children. So I think that tells me that the Ms. Tabbitt, I think that's her name, the CPS worker, indicated that Talbot, thank you. It indicated that she's indication is that the founded letter would be forthcoming probably by the end of this week. My thought is that two options. One, I'm going to grant the restraint, but I'm going to allow Mr. Jablonski to have some visitation, and we'll talk about that in a moment. But whether this order becomes the final order or continues to be a temporary order for a period of time, that's kind of what I'm struggling or thinking about now, because there's forthcoming information that we're going to have. One, I'm assuming we'll get confirmation from CPS related to the founded finding, and then we'll have forthcoming information from law enforcement what their thought is. So law enforcement may come back and say, hey, we're not pursuing this, or they submit it to the prosecuting attorney, or the DA says, no, we're not pursuing it, or they may say, yes, we are. Both of those would have an impact on whether the order would be permanent or a final order or a temporary order. Obviously, if they're pursuing charges, that would be likely. I don't think it'd be unreasonable for that order to stay in effect for a longer period of time, because those cases take a while to be work their way through the system. So let me just think on that just for a moment, and then I'll hear from the parties if you have any comments about my comments. But hold on for a second while you just give me a moment to think.
Excuse me, Judge, can you repeat that last bit? I had trouble hearing it.
Oh, the last little bit was just give me a second to think about whether about a final restraining order being put in place, or if it's a temporary and we set it out for a period of time to receive the other finalized reports from CPS, and also a final determination as far as law enforcement's perspective.
Oh, okay.
Excuse me, sir. This is Cassie Talbot with Child Welfare again. Is there anything else that you need from me? I do have to go.
Nope, I'm good. Thank you for being here.
Thank you.
Before I make that decision on the temporary or final restraining order, Ms. Jablonski had indicated she wanted to go back to the plan from 2018, the parenting plan. At this point, I'm not going to do that. I think there's enough concern related to the investigation regarding Chris or Mr. Vaughn to not do that. So I want to hear any suggestions you have related to visitation. So I think it's important that you have contact with the children. I think it's important they have contact with you. But I'm not going to grant the weekends as laid out in that. So I'm thinking more of maybe like Saturday visits. I know there's a tremendous amount of drive time involved traveling to that area. And so I just want to hear what if there's any suggestions that you may have.
I'm open to anytime on weekends, Saturdays or Sundays. That works for me.
Okay.
So I had already thrown out that I was willing to go to Pendleton, Oregon to have visitation supervised. Now, I was told by Cassie Talbot that I could not do that it was jeopardizing the case. So I did not. And then I was told by my social worker, Scott, that I could have a CPS worker supervise because I was uncomfortable having grandmother supervise, considering we have a lot of history and I just didn't feel safe. Now I'm okay with dad supervising and I'm okay with doing all my phone conversations with him, but I will not go through his mother. And I'm willing to meet him halfway, say at a park on Saturday or something to see my children.
Okay, thanks. Mr. Lyon?
Yes, I'm here.
What's your input related to mother having visitation? I think it's important that you have visitation with kids. I think it's important for the kids to have visitation with mom. Ms. Jablonski's laid out some options. What are your thoughts?
I am open to visitations here in Pendleton. I'm open to that.
Ms. Jablonski mentioned that she felt comfortable if you acted as a supervisor.
Yeah, I'm perfectly fine with that too.
She also mentioned potential meeting halfway.
Is there a way that I can leave that as an option? Like we can optionally meet there, or?
I just kind of want to know your thoughts about that.
For Pendleton, but I mean, if you need it to be halfway, I'll go halfway, Judge.
Okay. Ms. Jablonski, as far as, and Mr. Lyon also, Saturday, Sunday, is there a better day?
Either or, they're both fine with me.
Mr. Lyon, Ms. Jablonski said Saturdays is her preference. And then could you repeat what you said?
Can you hear me?
Yeah,
Hello?
I can.
Oh,
I can.
okay. No, there's not really a preference. Either one.
Okay.
She would probably prefer Saturdays because I know Sundays she has church, so it's up to her.
Okay. Ms. Jablonski, recognizing that's as far as cost for driving, whether you're driving all the way down or you're meeting halfway, is that something you want to do on a every week basis or an alternating week basis?
So we're talking about either a temporary or a permanent. I would like to, at this time, put another temporary plan in place until we get answers from the detective in regards to this case, because this is the first I've heard from Cassie since March 6th, when she told me she had no new information. And from my understanding is she's supposed to have that talk with me before she come and say things. So that was not done proper.
So regarding Saturday or Sunday, if you wanted every week, what's your input on that?
I want it every week.
Okay. All right.
Was that every other week or every week?
I think she said every week.
Oh, okay.
Okay. Any final comments from either Ms. Jablonski or Mr. Lyon?
Not really, but I will say as far as like the communication with Ms. Talbot and all that, there are some emails that were submitted with her with Ms. Jablonski on the 12th that show a misspelt email address. That would probably be why Ms. Talbot didn't respond, because she never got them.
Okay.
Which Scott addressed that, and we had fixed it and resent those emails.
Thanks.
It shows in a copy on the emails.
Okay.
Yeah.
All right, give me just one moment, please. I'll give you my decision. Length of the visits. Say you meet in Pendleton, or you meet halfway at a public location or some fun place. Length of the visit on Saturday.
I'll be willing to do longer visitations if Mr. Jablonski is interested in coming to Pendleton. I can do up to 6 to 8 hours in Pendleton. If I have to drive halfway, I'll probably cut it down to like 4.
Okay. Mr. Jablonski?
I'm willing to do for and not drive to Pendleton. I would like to try and limit that. I'm there strictly to watch my children, not to try and amend my relationship with Mr. Lyon. I don't want for that to happen. And there has been issues where he's like, let's try and get the family back together. I don't want for that. I want to just focus on my children alone.
Yeah,
And
definitely.
just have him stand by observer meeting.
Yeah,
That's all I want.
that's the purpose. That's the purpose
Okay.
of the visits. The purpose is not a reconciliatory effort. It's a visit between mother and children.
Yes,
I'm okay
exactly.
with just 4 hours.
Okay. All right. Okay. I appreciate the parties, your input. This is a very difficult situation at best. I can't imagine the different stresses that are ongoing that each party is experiencing, challenging at best. The temporary restraining order, what I'm going to make it a temporary restraining order, and I'm going to continue it for 60 days, 60, where we'll be back to take a look and see if there's new information, if that again becomes final.
I got a question for you. Is there any way we could make that shorter, considering the case started on January 26th to be exact? CPS told me that it's a 3-month thing, 90 days, and they should have answers on whether it's founded or unfounded. And when I spoke with the detective, I think we should have answers within like the next 2 weeks, to be honest. Is everyone I spoke to said, we're getting ready to close it out. So
Okay. All right.
if we can move it up, that would be preferred.
Okay. Mr. Lyon, any comment on that?
I would just say that I would prefer it to be the initial 60 days that you had mentioned, Judge.
Okay. All right, so I think I'll amend that and we'll continue it to April 24th. April 24th, so it's about 5 weeks, 6 weeks, so kind of splitting the baby, if you will.
Okay.
So those same restraints will be in place as in the prior temporary restraint order. However, I'm going to carve out an exception for visitation for Ms. Jablonski to be with the children, and it'll be this. So looking at a calendar, you'll look at the calendar and looking at and it'll be the second and the fourth Saturdays of each month. That'll be a halfway point at a public location, and that'll be for a visitation of 4 hours. And then the first, third, and fifth Saturdays, those will be in Pendleton, and that will be up to 8 hours. Both of those visitations will be supervised by Mr. Lyon. Obviously, Mr. Vaughn is not to participate and be present during those visits. I think that goes without saying. And any issues with that?
No.
Okay. And then he'll be the supervisor. And it sounds like then there also just no efforts of reconciliation or discussion of the relationship between the parties. Obviously, they can talk about the children if they want, and then it'll be primarily a visit for Ms. Jablonski. So I'll draft that order and then get it out to the parties according to the addresses that are in the file. Any clarification or questions?
I just want to make it clear in that order, just like we had with our phone conversations, like the video chats and the phone calls.
Yeah, that can happen.
Well, I just want those to be strictly monitored by Dad. I do not want his mother reaching out to me. I do not want her at visitations either, just strictly him.
Any concerns with that, Mr. Lyon?
Nope.
Okay. So yeah, I'll make that clear within the order. No, we'll call it maternal grandmother in reference to the children. So no maternal grandmother. And then as far as video and phone, that'll just be at reasonable time and reasonable durations, and monitored by Mr. Lyon.
Sounds good to me.
Thanks. Anything else, Mr. Jablonski?
No, that's everything.
Okay, Mr. Lyon, anything else?
Yeah. So you set up like, so basically every week we're gonna be going to Pendleton. Every other week we'll be meeting somewhere halfway, probably like Hood River, I imagine, or somewhere like that. Is there any way I can get like that schedule like sent to me so that way I kind of know which Saturday is which?
Yeah, so let's think about that. This Saturday is the 23rd. If you look at the calendar and you start on the calendar, there's a Saturday, the 2nd, 9th, 16th, and 23rd. So this would be the fourth. This would be the fourth Saturday of the month. So that would mean a halfway this week on Saturday, and on the 30th, the following week, since that's the 5th, that would be in Pendleton.
Okay.
And then it would just alternate between those two.
Okay, sounds good.
So Judge, we're gonna do this Saturday halfway.
Yeah, Saturday the 23rd is halfway.
And then
That's
next
four.
Saturday would be Pendleton.
And that's the fifth Saturday. That'll be in Pendleton. Then you look at April 6th. That's going to be the first Saturday in the month. So that will also be Pendleton. Then the 13th would be the second Saturday of the month. So that would be the halfway point. And then on the 20th, that would be the third. So that would be in Pendleton. And we'll be here on the 24th. Mr. Lyon, did you catch all that?
Yeah, so this weekend would be halfway, and then the next 2 weekends are going to be in Pendleton.
Yep.
13th would be halfway, and then the 20th would be in Pendleton again.
Yes, sir.
All right, then I got it understanding.
Okay. Any final items, Mr. Blonsky?
Not that I can think of, no.
Okay. Mr. Lyon, any final items?
No, not this time.
Okay, I'll get that order out to you all before Friday close of business, so you have that for your records.
We're back here.
Okay, sounds good.
Oh, one moment. There's a question from Ms. Jablonski.
We're back April 24th at 9.
Yeah, we're back here on April 24th at 9 a.m. Okay.
Hopefully I'll have some new information.
Okay. All right. Very good. Appreciate the party's input. Thank you very much.
Thank you.
And looks like Ms. Long is present, and you go by Ms. Long now, correct?
Yes, thank you.
Great. Appreciate that. I see Mr. Lawrence is patiently waited. Thank you. Mr. Lawrence is here also. And Mr. Francisco Gutierrez, are you here?
Yes, I'm here.
All right, great. Thank you. All right. So just I note that we're here today. We had a hearing on the 6th of March related to Mr. Gutierrez's motion to modify the parenting plan. And at that hearing, I asked the parties to provide additional information related to any proposed parenting plans. And it looks like I had indicated that Mr. Gutierrez would have to file his input by March 8th. I don't see anything that he filed. I did see that Ms. Long had filed a document on the 15th, a two-page declaration that she filed. So I don't know if we're in a wholly better situation than we were before. I think we have a little more information based on Ms. Long's declaration, but I didn't hear anything additional from Mr. Gutierrez. Mr. Gutierrez, did you file something and I just didn't get it?
Yes, I did.
Okay, what did you file?
A declaration paper that you asked me to file.
Okay, how many pages was it?
It was just the two-page, I think it's Form 101 page.
So I see the two-page declaration you filed back on March 6th. It says, I'm the father of Carson, Nathan, Isaac, Luke, and Stella.
That's the one.
I believe that's what you wanted, right? That's what you wanted me to do, the declaration form.
So that's the same day of the hearing. You signed it and you brought it down and filed the same day just after we got off the call.
Yes, I got off work and I drove to Longview and I did that.
Okay. All right. And Ms. Long, did you get a copy of that?
Yes, I did.
Okay. And Mr. Gutierrez, did you get a copy of Ms. Long's two-page declaration?
Yes, I did.
Okay. And Mr. Lawrence, did you get a copy of those documents?
No, Your Honor, neither. I did see Ms. Long's filing yesterday when I reviewed the file, and I did not catch Mr. Gutierrez's filing.
Okay. All right. Well, I'll be transparent with you. When I was reviewing the file, I know we had that hearing on the 6th, and I know that I was anticipating something being filed by Mr. Gutierrez by the 8th. So I was looking for something post-dated from March 6th. So I wasn't necessarily looking back at that March 6th because Mr. Gutierrez was right on it, came down here and submitted that. He indicates that he's been doing and trying his hardest to comply with everything the court has asked him to do to obtain visitation with my children. I miss them as much as they miss me because of court regulations and financial regulations. I am missing out on my kids, spending quality time and making memories with them. They do not consistently have their father in their lives at the moment. With a fair support calculation and parenting schedule, stability and quality time will be restored and our father and daughter-son bonds will strengthen. So that's what he wrote. And then Ms. Long wrote, I'm aware that Francisco is in compliance with his rehab program through Kaiser. I think it's in the best interest of the children that we go back to our original parenting plan. Do not feel that any modification to the parenting plan would be beneficial to any of us. Currently and also in the past, Francisco has been very inconsistent with his visits. I've already spoken with him and would be okay removing his weekday visits and giving him every weekend due to his work schedule. I feel that he needs to prove he's capable of showing up and doing his visits every other weekend with current parenting plan. If he can show 6 months of consistency, I will not contest a modification for every weekend. As of today, I would like to follow our original parenting plan and go back to unsupervised visits. In the past 30 days, he's only seen the children once and he spoke to them on the phone 3 times. Children need consistency. He needs to prove that he can do that for them. So that's the new inputted information. Mr. Lawrence, with that, I recognize you're just hearing that for the first time. I don't know if you're in a position to comment or if it would be premature.
Your Honor, I apologize if I miscommunicated. I did have a chance to review Ms. Long's statement.
Yeah.
I don't object to Ms. Long's suggestion. My only concern, and I would ask the court to adopt a recommendation that if the court decides to go back to the old parenting plan temporarily, that Mr. Gutierrez continue in his drug and alcohol treatment, and that he supply Ms. Long with compliance reports so that she is aware of his progress.
Okay. All right. Thank you. And then let me clarify with you, Ms. Long. In your declaration that you filed, you indicated that you want to go back to the parenting plan from June of 2022, and then you also indicated that you are open to every weekend, but then you kind of backtracked on that. So I'm not quite sure what you're wanting. If it's
So I know that
plan or every week.
So I want to stick to the original plan just to make sure that he's really capable of doing it, because as of right now, like, he's not showing up for visits. He's not calling. The kids ask for him all the time. So it's like they have to call to try to get a hold of him. And he's brought it up that he wants more time with them. And I understand that he works and he's living out in Gresham. So it is kind of hard and inconvenient for him to make it out here during the week. So I think that if he can prove that he'll at least do his every other weekends, I wouldn't be opposed to giving him the weekends and just having him during the week.
But you want to see compliance before making every week. And so until that time, you want to see it alternating weeks.
Yes, because right now I feel like he just wants it on paper because he wants child support adjusted. I'm fine with that eventually if he can prove that he actually will take them.
Okay. Thanks. Mr. Gutierrez, as far as the schedule, what's your preference?
I have no problem. I would love to have my time with my kids every weekend. I spent the last month trying to make it my way, however I can afford, to be able to live in Vancouver. I live in Vancouver now for about 3 weeks now, so I could be closer to work and closer to my kids. If there's a chance for me to be able to afford to live in Longview, I would take that. But at the moment, I can only do so much due to my financial situation.
Sure.
And I would have no problem to make time with my kids every weekend, or I'll take every other weekend for now.
Okay. So as far as housing, you said that you're in Vancouver now. Can you tell me what your housing situation is?
I stay with a girlfriend of mine, and it's a little difficult on my financial part. Basically, I just stay there because she lets me stay there.
Gotcha. Does she have children?
Her children, she has a daughter that lives with her, and she's 21 years old, and that's it.
Okay. Any other individuals that live in the home?
No, just her daughter, and me.
Do you know if your girlfriend has any criminal history conviction?
I believe she's had a DUI in the past, and that's about that. That's about it.
Okay. As far as the daughter, 21-year-old daughter, any criminal convictions that you're aware of?
No, not at all.
Okay. And is there, and forgive me just one moment, the children we're talking about here are now, there's 5 children, ages ranging from 12 to 2, roughly?
13 to 4.
13 to 4. Okay. They grow up fast.
They do.
So, Mr. Gutierrez, as far as the new place you're in there in Vancouver with your girlfriend, is there space for the children?
To be honest, it's a 2-bedroom apartment, which her daughter has one room. We have the other one. I mean, there's plenty. The living room area, it's plenty big. And that's about, what I have for now. It's
Right.
we were trying to move into a 3-bedroom apartment so that I could have an extra room, or we could have an extra room for bunk beds or something set up for my kids. But again, due to my circumstances, I'm not able to be able to pay my more, I guess, or help out more with bills and my part of the rent and stuff like that.
Okay, thanks. Ms. Long, do you have any thoughts related to space and the children? Any concerns?
I think that they'd be fine for, every other weekend, staying the night.
Yeah. Right.
I have met his girlfriend. She's met the kids before, and we're very cordial. So.
Okay. And then, Mr. Gutierrez, I'm just having, and maybe you can provide me some assistance on this. As far as your motion to modify the parenting plan, how long ago did you file that? How long has it been since you initially filed?
I believe it was in September, because the reason I did it then is because I didn't have nobody at the time. I was spending time in my car, and I was hoping would have a place of my own. Yeah, I was just struggling at the time, and that's why I was just searching for something to just get on my feet.
Right.
Income to get on my feet, basically.
Right. Okay. All right. I appreciate that clarification.
But at the time, child support, instead of maybe possibly being lower because my pay wasn't lowered at work, child support just got higher for me, and the struggle just became more of a struggle.
Sure. Yeah. Okay. All right. So at this point, it sounds like, the salient issue is, as far as Mr. Gutierrez, he's in compliance with his treatment. And Mr. Lawrence's suggestion is well taken, to have Mr. Gutierrez provide monthly compliance reports as far as his treatment. So that means, Mr. Gutierrez, continue on what you're doing with your treatment, engage, be in compliance, and then we'll need a report filed each month, supplied to Ms. Long and Mr. Lawrence, indicating that your treatment compliance, your treatment status, and hopefully it'll continue to be compliant. But that just needs to be done on a monthly basis. You can talk to your counselor, and they can help with that. Yes, go ahead.
I was just going to ask, the monthly report from my counselor, is that something I need to do on the last week of the month, the first week of the month, or is there a specific date? It's
a great question. I appreciate the question. So for the month prior, it should be the week following that month that the report should go out.
So the last week?
So the first week of the next month. So for example, your compliance
Okay.
March, you'd have to have that out by April 5th, the first week of the next month, or the following month.
Okay, got it.
Good. So as far as the motion to modify the parenting plan, at this point, this motion has been pending a long time, 6 months, and a lot has happened during those 6 months. Mr. Gutierrez is doing a lot better. He's still struggling financially, and it's tough out there. But he's doing better as far as with the SUD, substance use disorder treatment and the like, and that seems to be controlled at this point. So I'm going to deny the motion to modify the parenting plan, and the parties will continue to follow the parenting plan issued on June of 2022. I recognize that there's a midweek provision, and if that's cost prohibitive, the parties have to kind of figure that out. But if it can happen, it should happen. Sounds like Mr. Gutierrez might be in a position where it's easier for him to do that since he's closer. And then the weekend visits, as noted in the parenting plan, will continue. I am going to add that one caveat of continuing compliance with SUD treatment, and then provide the compliance reports to Ms. Long. So that'll be the court's order. So I'm just putting a notation here that I'm denying the motion to modify the parenting plan. I'll do an order that keeps the June 3rd, 2022 parenting order in place, and the parties will follow that. So that'll at least that concludes the matters that were before the court. And I'll just ask if there's any questions or clarifications. Mr. Lawrence?
No questions, Your Honor.
Thank you. Ms. Long, any questions or comments?
No.
Mr. Gutierrez?
Just as far as like my financial circumstance, is the child support going to stay the same, or is it going to go back to the $1,240 to there was on the June of 2022, I believe, parenting plan? I mean, like I said, when I turned in paperwork on on September of 2023, I turned in some pay stubs as well, on regards of my pay being lowered.
Right. So there's the initial June 3rd, 2022 child support order where it shows Ms. Long with a net income of $2,700, Mr. Gutierrez at $4,500, and that set a transfer payment of about $1,240. Does that sound right?
Yeah, that was the original one. That was the first one.
And then you filed your motion related to the child support back in September of 2023, where you indicate that there's an incident of domestic violence in January 23, and then the no contact order, and you got the drug evaluation done, and that you're asking for a 50-50 custody arrangement, spend time with the kids. And looks like that was the basis of the motion or change request, is that you were asking for a 50-50 parenting plan, with us now going to just the June 2022 parenting plan with the weekends and the like. I don't know if there's a basis to modify that. So, Mr. Gutierrez?
I mean, what do I need to refile the paperwork? Do I need to update?
So you said back in June, or pardon me, September, that you're getting paid about $650 a check, or twice a month. Has that changed? Is that different?
That's pretty much what I'm getting, like, for me, after fees and taxes and child support and everything being taken out. Yes, that's still about the same.
Okay. So it looks like there was an updated support order in November of 2023 that moved it to $1,573 per month.
That was child support enforcement. They took over.
Yes. So any issue related to child support we need to have child support enforcement present. They're unfortunately not here today. They were here earlier. And I can see why they may have thought that the case wasn't on for this particular issue, because it was 6 months ago that the petition was filed.
They already did their modification, though.
Yeah, back on November 2023, correct?
Yes. So they already completed their part of this filing that he did.
Yeah.
That was them doing their modification, and they actually raised it.
Right. Yeah, it went up. Mr. Gutierrez, are you since you filed in September, have you changed jobs? Has your income changed? Your financial situation changed?
No, it's stayed about the same. If I give you if I was to turn in another 2 pay stubs to the court, they probably the numbers will be just about the same or pretty close.
Okay. That's helpful. I appreciate everybody's input. So as far as that motion to modify the child support, I'm going to deny that motion because there's been no significant or substantial change in the situation of Mr. Gutierrez, and especially since there was a denial of the modification of the parenting plan. So I'm going to deny that motion to modify the parenting plan. All of that will be included in an order that I'll get out to the parties before Friday afternoon. So that concludes the hearing. So just any final points of clarification?
Go ahead.
I was gonna say that I will not be able to have my kids until the weekend of April 6th, because this weekend I will be leaving town to go visit my mom, and I'm not coming back until the following weekend. So
okay. Maybe what we could do, Mr. Gutierrez, that sounds like that'd be a good communication for you and Ms. Long to have about the kids. So allow you to have that offline. Other than that issue that you need to talk to Ms. Long about, any other issues that we need to address today?
No.
I guess not.
Okay, Mr. Lawrence.
No.
Appreciate everybody's time and input. That'll conclude the hearing today. Thank you.
Thank
you, Your Honor.
All right. So at this point, that concludes all the matters that were docketed. If any party was anticipating their case to be heard today but has not been, please speak up and we might be able to give you some assistance.
Yes, Your Honor. I had a case with Miss Angela Mosquita. It was supposed to come back on the 20th.
Yeah, I think they're coming back at a later date. Let me just pull that up.
Okay.
There was something that was filed just recently, and so that kind of jogs my memory. Let me just double check and see if we can find it.
Next Wednesday, the 27th at 9.
Okay. The clerk has confirmed that it's on for next Wednesday, March 27th at 9.
Okay. All right. Thank you, Your Honor.
Yeah. So we'll see you then. Thank you. All right. With that, I think we'll end the Zoom call, having completed the tasks before us today.